Hi, I'm Madison Kelly, a Senior Associate and Accredited Specialist in Coleman Greig's Family Law team. The Family Law Act has changed over time, but there have been some significant changes to the Act which came into effect on the 10th of June 2025. The key changes include expanding the definition of family violence, particularly to include reference to economic and financial control, expanding the factors to be considered by the court when making orders for property settlement and spouse maintenance, particularly as it relates to family violence, defining a companion animal and specifying the process for determining ownership into the future in relation to that animal, clarifying the duty of disclosure and specifying the consequences when it's not complied with, changing certain aspects and simplifying the divorce process, changing the initial stages of the case management pathway as it relates to parenting matters, and streamlining the process for cost orders. The section of the Act which defines family violence previously set out the various types of violence that exist. That includes things like physical assault, sexual assault, stalking, etc. The recent inclusion is that of economic or financial abuse. Whilst economic or financial abuse is something that the court has considered for some time, the recent changes to the Act are designed to specify the consideration of economic or financial abuse in the legislative pathway and ensure that the court meaningfully considers it. The section actually provides examples of behaviour which might constitute economic or financial abuse. Some key examples of that might be unreasonably denying the family member the financial autonomy that they may have had, such as by forcibly controlling their assets, sabotaging their employment or their potential for employment or income, forcing the family member to take on the responsibility of a liability, forcibly or without the family member's knowledge, having them accumulate debt in their own name that they did not realise. Another example is unreasonably withholding financial support. This often occurs in a situation where one party has not worked and has relied on their spouse for financial support, and the moment that the parties separate from each other, the financially superior party ceases all of that financial support. Family violence has been a consideration in relation to property settlements and spouse maintenance for some time. Previously, however, this arose in the context of case law. This came from the leading case of Kennan, a 1997 case. That case basically stipulated that the court could make an adjustment in favour of one party on account of the family violence that they may have experienced during the relationship that made their contributions to the relationship more arduous than they otherwise should have been. The intention of the changes to the Act is to codify that principle from Kennan and ensure it is included specifically in the legislation and that the court must consider it when making orders. Section 79 of the Family Law Act is the main section which dictates how the court makes orders in property settlement proceedings. There are 4 new factors that the court must consider when making orders for property settlement. The first is the effect of family violence. The effect of family violence will, of course, be considered in light of the updated definition of family violence, and so financial and economic abuse is going to become more relevant. The effect of any material wastage caused either intentionally or recklessly by a party. An example of this may be gambling, disposing of matrimonial assets without consent or under value or not at arm's length, or some more basic examples, like leasing out a property of the parties without charging rent for a significant period of time that had an impact of reducing the size of the asset pool or the income or resources that may have been available to the parties. The next factor is liabilities. Liabilities have always been considered, but it's now been legislated that the court will look at liabilities more closely, including how they impact upon the current and future circumstances and financial future of the parties. The fourth factor is housing needs. Previously, the court was to take into account if one party had the care of a child under the age of 18, and that remains the case. But the Act has been expanded to include the accommodation and housing needs of the child as well. And one for the pet lovers out there. Whilst the court previously had power to make orders in relation to animals, previously animals were treated as property. That meant that if the court was going to make orders in relation to a pet of the family, it really came down to who owned the pet, who paid for the pet, who registered the pet, and the relationship to a pet was really reduced to one of property. But if you have a pet at home, I'm sure you consider them more important to you than just any item of property. A companion animal is defined as an animal kept by the parties to the marriage or either of them, primarily for the purposes of companionship. But it does not include an assistance animal within the meaning of the Disability Discrimination Act, an animal kept as part of a business, an animal kept for agricultural purposes, or an animal kept for use in laboratory tests or experiments. So now, under the new changes, the court can make orders in relation to a companion animal, and the factors to be considered by the court when doing so are as follows. The circumstances in which the companion animal was acquired, who has ownership or possession of the companion animal, the extent to which each party cared for and paid for the maintenance of the companion animal, any family violence to which one party has subjected to or exposed the other party, any history of actual or threatened abuse towards the companion animal by one party, any attachment by a party or a child of the relationship to the companion animal, the demonstrated ability of each party to care for and maintain the companion animal into the future without the assistance of the other party, and any other fact or circumstances that, in the interest of justice, the court considers must be taken into account. Disclosure is also a really important part of family law proceedings, and the duty of disclosure has been codified in the Act. Whilst the duty of disclosure has always been important and significant emphasis has been placed on it, it has simply been clarified in the Act, and a greater emphasis has been applied to the consequences of not complying with those disclosure obligations. In relation to divorce, there are two key changes. The first change relates to when parties have been married for 2 years or less. Previously, there was a requirement that if parties had only been married for 2 years or less, they were required to consider reconciliation and file a certificate confirming that they had completed counselling before they made their application for divorce. This requirement has now been removed. The second change relates to attendance. There are effectively two ways to file a divorce application: joint or sole. Previously, if parties filed a joint application, but they had children under the age of 18 years, they were not required to attend a divorce hearing. However, if a party filed a sole application, that is, without the cooperation of the other party, they were required to attend the divorce hearing. The recent changes have clarified that irrespective of whether the application for divorce is a joint one or a sole one, the parties are not required to attend the divorce hearing, even if there are children under the age of 18 years. There are some other changes to the legislation, particularly as it relates to protecting sensitive information. It's not uncommon generally, or certainly in family law proceedings, that a party may attend upon a psychologist, psychiatrist, or counsellor, or another health practitioner designed for therapeutic purposes. The recent changes to the Act have been designed to protect sensitive information where it is not relevant. Particularly in parenting proceedings, attendance upon a psychologist, psychiatrist, or other counselling service may form part of a party's duty of disclosure. Prior to these changes, the impact of that disclosure often meant that the other party would issue a subpoena or seek the production of records relating to that therapeutic assistance. This often doesn't sit comfortably with a party who is trying to seek therapeutic assistance and be open and transparent with their practitioners, only for those records to be used against them later. The recent changes have empowered the court to make orders directing that such evidence may not be adduced, particularly if it would disclose a protected confidence. The court can make that directive either on its own motion or on application by one party. When considering whether or not to make that direction, the court must be satisfied that it is likely that harm would or might be caused, directly or indirectly, to the protected confider or to a child to whom the proceedings relate, if the evidence were adduced. And the nature and extent of the harm outweighs the desirability of adducing the evidence. And the final key change is streamlining cost orders. No significant changes have been made here. The cost provisions have simply been moved into a new section and are somewhat easier to understand. For guidance on what the changes to the Family Law Act mean for you and your family, get in touch with Coleman Greig's Family Law team today.